Hey, good morning, everyone. Welcome back to case number 94 of 46. The purpose of today's hearing is a scheduling conference on the settlement agreement and stipulation by the joint applicants, Montgomery County, Prince George's County, MEA, and LIUNA. So let's begin by taking appearances, and we'll start with the commission staff. Mr. Dean.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff.
Good morning, Chairman, Commissioners. Joseph Cleaver on behalf of the Office of People's Counsel.
Morning.
Good morning, Your Honors. Exceptional K. Caldwell on behalf of the Apartment and Office Building Association of Metropolitan Washington.
Good morning, Your Honor. Joseph Curran on behalf of the joint applicants, also joined by Mr. Paul Buckley on behalf of Washington Gas, as well as William Du Bois and Christopher Gunderson from Venable, who are also joining us today.
Good morning.
Good morning, Chairman, Commissioners. Lisa Brennan on behalf of Montgomery County, Maryland.
Good morning, Mr. Chairman and Commissioners. Michelle Honeck on behalf of MEA.
Good morning, Mr. Chairman and Commissioners. James McGee with Alexander and Cleaver on behalf of Prince George's County.
Commissioners, Mr. Chairman, my name is James Wallington. I'm here on behalf of the Office and Professional Employees International Union, Local 2, AFL-CIO, intervener in the case.
Good morning.
Good morning, Commissioners. On behalf of LIUNA, Brian Petruska.
Andrew Pizer for NCLC, NHT, MAHC, and HAND.
Good morning.
Good morning. I am Emily Medlin on behalf of the United States Department of Defense and all other federal executive agencies.
Good morning. Okay, is that everyone? All right, why don't we first take up our procedural schedule, and I know we have disagreement as to the filing time for testimony, so why don't we start, we'll start with the non-settling parties, and we'll begin with the commission staff. Mr. Dean.
Thank you, Your Honor. We've had some discussions with the settling parties through the joint applicants, and we've proposed a schedule with a filing date of testimony by the parties in support of the settlement of January 5, 2018, which is 30 days since the notice that the Commission issued on December 4th. Testimony by the non-settling parties would be on January 29 by noon on that day, which is a Monday. And as I understand it, the Commission has penciled in hearing dates of February 5, 6, 7, and 8. We've also proposed a single date for briefs by all parties on March 5, which is 30 days prior to when the order would be due on April 4. As I understand it, the settling parties have proposed their filing date as being January 12th, and testimony by the other parties on January 26th. Those are the only differences as I understand it. We believe our dates are more appropriate. There's been 30 days since the notice of December 4 that notified everyone that we would have additional evidentiary hearings on this, so everyone's been on notice since then that testimony would be due. So we provided 30 days to January 5 for the settling parties to prepare their testimony. We also believe our proposed dates is a much fairer division of the total time available to all the parties. And we note that there are several complications in the settlement in regards to conditions that haven't been discussed before, and will need to review the testimony in support of these conditions to explain how they work in order to prepare the, speaking for staff, our testimony. And as a result, we'll need the full amount of time between the filing by the parties in support of the settlement and then the January 29th date for staff. I have not discussed this with the other parties yet, but we'll also need to just discuss the discovery periods.
All right, we'll do that after we work out the procedural schedule.
Thank you, Your Honor.
All right, thank you, Mr. Dean. Any other comments from the non-settling parties? Mr. Cleveland.
Yes, Your Honor, thank you. Your Honor, OPC largely echoes what Mr. Dean just stated on the record. OPC's view is that the 14 days turnaround time between the settling testimony and the non-settling testimony is unreasonable in light of the nature of some of the provisions in the settlement agreement. Just a couple examples. There's a provision regarding NAFTA. There was a lot of discussion, cross-examination done in the District of Columbia last week regarding the Maryland settlement provision and what it may mean. My takeaway is that in OPC's view, the questions that were asked down in the District of Columbia regarding this settlement provision raised a number of additional questions. There's no information in this record as to what that may mean, and there's very little information on the NAFTA issue generally. There's also a settlement provision, as the Commission knows, regarding a commitment to attempt to add $70 million to rate base. That's an issue that requires a lot of analysis and understanding as to how that works. Again, like the NAFTA provision, raises a lot of questions. Also, the $33 million fund to be administered by the MEA. These are very uncommon provisions that we've never seen in a settlement before. I'm sure you'll hear applicants say that, well, these are largely similar to what was presented in the record in this case, but we strongly disagree with that. The applicants have also said, you may hear from them that, well, we agreed to 4 months to provide ample time for the parties to review, but that's not reflected in this proposed settlement turnaround time that they're proposing. A lot of discovery has been propounded, but there's still a lot of questions remaining, and until we see that responsive testimony or the testimony on the settlement terms, we won't be able to, in the words of the Commission in this procedural order, fully evaluate the request. I would also note that the timing of all the filings in this proceeding is under the applicant's control. So to the extent that the applicants are unhappy with where these dates fall, that was determined by when the application was filed and when the settlement was filed. The 24 days turnaround time that staff has proposed and that OPC agrees with is still a tight schedule, but it's far more reasonable and workable than the 14 that the applicants have proposed. Thank you.
All right, thank you, Mr. Cleaver. Mr. Caldwell, anything you want to add?
Just to join the comments of staff and OPC, AOBA fully supports what was just said by the non-settling parties, Your Honor.
All right, thank you. Any other comments from non-settling parties on the schedule for testimony? All right, if not, let's go to the settling parties. Mr. Buckley, you want to start us?
Actually, Mr. Curran is going to...
Good morning, Your Honor. I think to start, we may just want to take some precedent or view from our prior 6105 proceedings and in our prior cases that have reached a settlement and have been reviewed by the Commission. The intervening parties were given between 15 and 35 days from the settlement to the process of filing rebuttal testimony. Under this proposed schedule, they'd have essentially 2 months from the filing of the settlement agreement on December 1st to the end of the month, and it's right on the eve, Your Honor, of the hearings. The joint applicants under the proposed schedule by staff would have essentially no time at all to be provided with any discovery in response to those comments. Another concern based on the proceeding itself, when we did have testimony due right on the eve of hearings, we received about 200 pages of surrebuttal testimony right before our initial evidentiary hearing started, and it became very challenging to respond to that in a meaningful way. What we would propose is basically look at both the Exelon Constellation case and the Exelon Pepco case. In both of those proceedings, there was concurrent testimony filed by both the settling parties and the non-settling parties. That seemed to work well for the commission, and then have a period for them to respond to that testimony. So what we have proposed is on January 12th, have all the parties, they'll have 42 days from the time the settlement agreement was entered to the time to prepare and file testimony, 42 days to file all parties file concurrent testimony, and then give them essentially about a 2-week period to the 26th for all parties to file reply testimony. This will give the commission a very robust record prior to our February 6th hearing dates. I know there may be a conflict on the February 5th date we can talk about later. But that seemed to work well in prior cases, and we deem would be appropriate here. The vast majority of the issues that are in the settlement agreement itself were discussed. Certainly gas expansion, workforce development, energy efficiency programs, all those components of the settlement were at some point in time discussed in either testimony or at the hearings before the commission. So, and when you look back, quite frankly, on the prior proceedings, which took a lot shorter time to prepare testimony, they involved significant issues that aren't dissimilar to, in fact, in many ways, were more expansive than what we're talking about in this proceeding. There was market power testimony that needed to be prepared. We got that done in 7 days. There was a $30 million offshore wind study that was part of those settlements. There was 300 megawatts of new generation that were part of those settlements. All of that was able to be entertained by the commission in a much shorter period of time than the staff and the non-settling parties are arguing for this case. The other compelling reason to go to January 12th, Your Honor, is there is some unavailability of some of the witnesses that will be filing testimony, and I'll let MEA and the counties discuss some of their concerns about being able to get their witness testimony in at that time. But if you look back at what we've done in prior cases, this is what they're asking for is a significantly longer period of time, and really provides us the opportunity to respond in a non-meaningful way. We'd be getting the testimony on the 29th. We'd be starting the hearings the next week. We'd have absolutely no discovery that we could propound. And it would, I don't think, provide for a very robust response or a strong presentation for the commission. Actually, having 2 rounds of testimony on the 12th and on the 26th probably ends up in narrowing the issues for the commission's consideration instead of expanding them. So we would respectfully disagree with what is proposed by staff and the non-settling parties, and just ask that you take direction from the prior cases that have been successfully entertained by the commission in the past, with a much more abbreviated schedule than's being requested here.
Well, Mr. Kern, let me ask you, since you're arguing that a lot of these issues in this settlement are either similar to prior settlements or not as complex, what is the concern with the settling parties getting their testimony in by January the 5th? It seems like that shouldn't, I mean, that's 5 weeks from the time the settlement was filed with the commission.
That's a great question, Your Honor. We do have some of our colleagues that want MEA to have a chance in the counties. They do have a review process, and they have some of unavailability issues by the 5th, and they also have a review process that they'd have to undergo. But I understand that that's a concern of the commission, but I don't want to speak on behalf of MEA or the counties regarding those concerns.
All right, sounds like
Yeah.
we'll hear from them, though. It sounds like that's not as big an issue for the applicants as it is for the other settling parties.
But we would certainly support our
Okay.
settling parties because we understand that there is a review process that we don't have at the joint applicant level, but they do within state government and county government. So I will defer to them on that.
Okay, before we go to the other settling parties, any questions for Mr. Kern? Right. Thank you. Appreciate it. Okay, why don't we hear from any of the other settling parties who wish to be heard on the dates for filing of testimony?
Good morning, Michelle Honig on behalf of MEA. MEA strongly supports setting a date no earlier than January 12th as the date for settling parties to file testimony in support of the settlement. January 12th would take into account staff leave schedules that were set long in advance of the settlement and would also acknowledge the need for executive branch review before testimony could be filed. Also, I'd like to note that discovery has been ongoing since December 4th and continues as we speak. So discovery responses will provide targeted information that the other parties could use in preparation of testimony.
All right. Any questions for Yes, Commissioner O'Donnell.
So help me out here. I do have a question for you, if you would
Yes.
indulge me a little bit. You're asking for another week, right?
Yes.
A minimum of another week. But the state had to be crucial in its negotiations on the settlement. What does that extra week buy you? Could you expound upon that again?
Right. I mean, we're acknowledging that staff involved in preparation of testimony has made vacation plans, holiday plans, well in advance of what has happened in the interim. So that is that issue. It's a logistical issue. And the fact that any testimony that will be submitted must be vetted by the executive branch.
I appreciate that. I also appreciate that this is a multi-billion-dollar merger proposition. So thank you. I appreciate it.
Well, thank you. Any other parties wish to be heard?
I would basically echo what was just said by Ms. Honig. Montgomery County also has issues regarding staffing. We had anticipated at one point that our involvement would basically be done with a filing in November, essentially, and so people did make plans. So we do have issues regarding the staff who's working on this filing, as well as we also have the executive review process that Ms. Honig was mentioning. So basically it's the logistical issues that we have. So I would just basically echo her statement, and we strongly support filing the testimony on the 12th.
All right, thank you.
Thank you, Commissioners. Prince George's County agrees with everything the applicants and MEA and Montgomery County said, and there's one other wrinkle for us. Erica Bannerman is the primary witness for Prince George's County. She's unavailable on February 5th and 6th in terms of the hearings. I know typically the settling parties would present first, so I want to bring that to your attention, and that might cause an issue for us.
Okay. All right, before we take up the testimony, let's touch on the hearings. We've heard from Prince George's County, either Mr. Buckley or Mr. Curran, any issues, any conflicts on February 5th we should be aware of?
Yes, Your Honor, please. Thank you. Paul Buckley for Washington Gas. The company's anticipated witness, Mr. Chapman, is unavailable on February 5th, but would be available the rest of the week. There are a number of other work obligations, including board meetings for the rest of that week that we're already in process of moving, but he simply is not available on the 5th.
Okay.
So if we could start the hearings on at least the 6th, understanding we may have to make some accommodations for the Prince George's County witness to appear later, that would be greatly appreciated.
Okay, I think we can accommodate that request. and begin hearings on the 6th. So what we'll do is we'll plan on hearings to go from the 6th to the 9th. I think we expect probably 2 days of testimony from the settling parties. That would allow us to take Ms. Bannerman on February the 7th, if we do that. All right, so that will be our hearing dates, the 6th through the 9th. All right, on to the schedule for testimony. I think the Commission agrees with staff and with OPC and AOBA on their request. So we're going to set testimony by in support of the settlement on January 5th, testimony by other parties on January 29th at noon. Let's go to the discovery request. Mr. Dean, do you want to make a request in terms of discovery limits?
We believe the 5-day turnaround period is appropriate right now, up through the filing date of testimony by the settling parties, and then after that, to ensure that the amount of discovery that can be accommodated is accomplished. We would like it to go down to 3 days for the turnaround at that period of similar to what was done earlier in the proceeding.
So starting January 5th?
Yes.
Okay. Any concerns with that for discovery?
After the 5th, that shouldn't be a problem. Our issue will be the turnaround. If the interveners are filing their testimony on the 29th, Your Honor, for us to get any meaningful discovery out, we'll need to have it a 1-day turnaround from the non-settling parties if we're going to get any meaningful discovery out before our February 6th hearing date.
Any concerns with from the 29th going to 1-day discovery turnaround? I mean, 3 days gets us close to the hearing, so we need to expedite.
We'll try to accommodate. There may be specific questions, of course, that are difficult to write up and provide the information for in 1 day, but we certainly will do our best.
Your Honor, I would note for the Commission's consideration that a 2-day turnaround during that period would allow a set of discovery questions and then a follow-up set.
Why don't we do this? We'll ask that the non-settling parties make their very best efforts to turn around requests in 1 day, but we'll set the limit at 2 days. Okay, in terms of briefs, we know there's agreement on briefs for March the 5th. However, the Commission needs briefs a little bit earlier, so I'd like to set the brief due on March the 1st. Why don't we do that? Okay, finally, in terms of our end, we expect both in terms of testimony and at our evidentiary hearings, we will hear for not only the settlement that was filed, but anything that is part of the conditions that has been offered after the close of our evidentiary hearings will also be part of this proceeding. Mr. Dean, then Mr. Cleve.
Briefly, Your Honor, just for the record, some of our witnesses may not be available on the 9th, so we'll have to get the witness schedule set up for that. It may be somewhat out of order.
All right, we'll try to work with you on that. I mean, I think we can expect that February 8th and 9th will probably be for non-settling party witnesses, although there may be a little bit of overlap there. So you can try your best to work with those 2 days, and if that doesn't work, then we'll try to accommodate all the witnesses in their schedules. Okay, anything else?
Yep.
Yes, I'm sorry, Mr. Cleve.
Oh, thank you, Your Honor.
Sorry.
Your Honor, mindful that the Commission's procedural order says that discovery is limited to the settlement, and mindful of Your Honor's comments of a moment ago, one thing that has recently come to light, though, is the fact that a change in the corporate tax rate from 35% to 21% appears to be imminent. And to the extent that that touches upon any of the issues that have been raised in this proceeding, we would ask for Commission permission to propound discovery on those issues and to address that in testimony if necessary.
All right. Why don't we do this? Why don't we do this? I don't think we're ready to rule on that today, but if you make that request, if the applicants have any concerns, you can bring that to the commission, and we'll rule on it at that time.
Should the request be made by motion, Your Honor?
Yes.
Okay. Thank you.
Anything else? Yes. Oh yeah. For discovery, the 3 days and 1 day, those of course will be business days. All right. Anything else before we adjourn? All right. Thanks, everyone. Look forward to seeing you on February the 6th.
Thank you.